Your divorce attorney charges by the hour to clean up communication mistakes. The judge forms opinions based on a handful of screenshots. And the guardian ad litem, if one is appointed, reads everything. In an Illinois divorce, your words are not just words. They are exhibits. This video gives you the communication framework that keeps everything you write working for you, not against you. Under 750 ILCS 5, Section 603.10, a court can restrict or modify parenting time if a parent's conduct endangers the child's mental, moral, or physical health. That threshold is lower than most fathers expect. It does not require physical violence. Documented patterns of harassment, intimidation, or erratic communication can clear that bar. More importantly, Section 602.7, the best interest standard, specifically considers the willingness and ability of each parent to facilitate and support the other parent's relationship with the child. If your texts show contempt for the other parent, the court reads that as contempt for your child's relationship with their mother. That reading costs you parenting time. The statute is that direct. Most fathers lose ground in communication, not because they are bad people, but because they are reacting like human beings in an abnormal situation. You are co-parenting with someone who may currently be your adversary in a legal proceeding. The rules of that relationship are completely different from a normal one. What feels like a reasonable response in a normal relationship can read as threatening or unstable in a court document. Here is the reality. Opposing counsel is not reading your text to understand your point of view. They are reading them to find one sentence, one word, that paints a picture they can use. You are writing for a reader you have never met, who is actively looking for problems. That changes how you write. Rule 1. Never threaten, directly or indirectly. This includes statements like, "You will regret this," or "The judge will see who you really are." Even if you are correct, it reads as intimidation. Do not write it. Rule 2. Never litigate over text. Do not argue the merits of your case, dispute her version of events, or try to win an argument in a message thread. That is what attorneys in courtrooms are for. Rule 3. Never involve the children in adult communication. Do not reference what the children said about the other parent. Do not ask children to pass messages. Do not copy children on communications. Rule 4. Never send messages when you are activated, angry, exhausted, drinking, or emotionally flooded. None of these are writing conditions. Walk away from your phone first. Rule 5. Never use sarcasm or humor about the case. It does not translate in print. It reads as contempt. When you do respond, use the BIFF framework developed by conflict resolution expert Bill Eddy. B stands for brief, keep it short. Long messages invite long arguments. I stands for informative. Stick to facts, logistics, schedules, medical information, the business of co-parenting. F stands for friendly, not warm, not intimate. Professionally courteous. The tone of a business email with someone you respect but do not know well. The second F stands for firm. State your position once. Do not over-explain or justify. One clear statement is more legally credible than 3 paragraphs of defense. A BIFF message might look like this. I can pick up the kids at 6 p.m. on Friday. Please let me know if there are any schedule changes by Thursday morning. That is it. No more. Save every communication you receive with timestamps. Screenshot and back up to a secure folder that is not shared with anyone. Before sending any message, ask yourself 3 questions. Would I be comfortable if a judge read this? Does this move the co-parenting relationship forward? Is this necessary right now? If you are using standard text, create a separate contact in your phone for co-parenting communication. Label it something neutral. That mental separation helps regulate your tone. Use our Family Wizard or a similar documented platform for all non-emergency communication. The link is in the description. Brief your attorney on any communication thread that concerns you before it becomes a problem in court. If you are in an Illinois divorce and you are co-parenting through standard text right now, that is a vulnerability. Move the conversation to a documented platform. In video 3, we cover the hardest scenario. What happens when you are doing everything right and the other party is not? Provocation tactics, reactive abuse, and the Gray Rock method, a documented behavioral strategy for high-conflict co-parenting situations. This content is for educational purposes only and does not constitute legal advice. Every case is fact-specific. For advice tailored to your situation, consult a licensed Illinois family law attorney. The creator of this channel is not a lawyer. Psychological concepts referenced are from published research and are not a substitute for professional counseling. This is principled fatherhood. We don't vent, we strategize. Stay principled.